If you're injured in a construction accident, there are many laws that protect you and that require that the construction site be operated in a safe manner. The law often makes an owner or a general contractor responsible for a construction site accident, even if they didn't directly cause it. So if you're a construction worker and you're injured on a job site, make sure that you know the names and the addresses of all of the contractors on the site. You want to know who the owner was, you want to know who the general contractor was. Often that information is on signs on the construction site, including license numbers or Department of Building numbers. You should take pictures of those signs and talk to your coworkers to find out which contractor or which subcontractor was responsible for site safety, who was the owner, and who was responsible for the particular thing that caused you to get hurt. When we agree to represent someone in a personal injury case, the first thing we do is we investigate. We send investigators to take photos of the accident scene, we collect medical reports and accident reports, and sometimes we bring legal action to get videotape or other evidence that the potential defendant has in the case. If after we investigate a case, we think that it's worth moving forward with a lawsuit, the first step in the process is we file a document called a complaint. The complaint tells the other person that we're suing them, and it tells them what we claim happened, and it tells them generally what injuries we're claiming and what damages we're seeking. A complaint is the legal document that starts a lawsuit. After we file the complaint, the other side will respond. The document that they send us when they respond is called an answer. And usually in the answer, they will deny many of the things that we're claiming, although sometimes they will admit some things. When the defendant in a personal injury case sends us an answer, they're also going to send us demands for more information about the case. Those demands are called a demand for a verified bill of particulars and discovery demands. When we get a demand for a verified bill of particulars, we must respond with particulars about who you are, what your injury is, what negligence we're claiming, who you were employed by, and other facts about the case. At that point, our staff will contact you to discuss the claim further and to get specific answers to you about the questions that we are being asked. We will then prepare the bill of particulars and we will ask you to sign it and have it notarized so that we can give the other side the information that we are obligated to give them and that they are entitled to have. Of course, we are also going to send demands to the other side for information and documents we want from them, and we may also ask them for particulars about any defenses that they raise. So this process, which we call discovery, is a two-way street where each side gets to ask the other side for documents and information about the claims and defenses. One piece of the discovery process is called examination before trial. After the paper documents are exchanged by both sides, there will usually be a preliminary conference in court, and the court will direct that each side gets to ask the other side questions about the case. What this means is that you will be called in to testify so that the defendant's attorneys can ask you questions under oath with a court reporter present to take down the questions and the answers. That examination before trial may take place in our office, it may take place in the defendant's office, or it may take place in the courthouse. We will also have an opportunity to question one or more witnesses from the other side depending on the nature of the case. Often after the examinations before trial are finished, each side wants more documents or more information from the other side about things they learned in the course of the examinations before trial. If that happens, there's additional discovery. When all of the discovery is complete, then and only then do we file a piece of paper called a note of issue with the court. That piece of paper tells the court that your case is ready for trial.